All right. Oh, we'll hand it to Connor, sorry.
Is this thing on? Fantastic. Okay, so before we get started, I just wanted to go off script a little bit and obviously thank our panelists who are very wonderful for sticking around and being here. I think that as organizers, it's always important to us to get a lot of attendance, but being here for the past however many hours, I've been incredibly struck by the passion and the insight from our speakers that has filled up the room. And it's been very comforting. And I know that just having this discussion and this conversation for anyone to hear has been incredibly valuable for me and quite potent and will leave certainly a lasting impression on me. So thank you again. We are really glad that you're all here, and it means quite a bit. So one other housekeeping matter to get out of the way, everyone's favorite issue, and why we're all here, of course, CLE credit. If you are online and a webinar person, please keep a lookout for the one or more codes that will be read out during the panel. If you're looking for CLE credit and you're here in person, make sure that you sign out with your signature, just like you signed in with your signature. We just need a timestamp and your signature. Thank you so much. I'm excited to receive a bunch of angry emails about you not getting your credit. Now, our last panel for the day offers a vital conversation on the criminalization of queerness in the United States. We'll discuss how the rights of incarcerated LGBTQ+ people continue to be violated, the carceral framework that those rights violations occur under, and how those rights can and must be affirmed. Our moderator for this panel is Molly Griffard. She's an assistant professor of lawyering at NYU School of Law, a 2019 graduate of the law school, alumni of NYU Review of Law and Social Change as well, and a co-founder of NYU's Identity Documents Project. Prior to joining the faculty here, Molly litigated federal civil rights cases challenging systemic police misconduct and served as policy counsel to the grassroots movement groups seeking an end to police violence. Before that, Molly served as an organizer and strategist on the LGBTQ+ state policy issues at the ACLU. Thank you so much for coming, and I will hand it over to you.
Thank you, Connor, and thank you to Connor and Nathaniel for organizing this colloquium, and to the speakers who had a really lively and great conversation before us. And I know as the day goes on, many of you were here, all day. We will try to offer just as lively and exciting of a conversation, and if nothing else, that CLE credit. So thank you all for being here. Let's see. On the CLE credit, I will share codes at a couple points throughout, so stay tuned for that. And we'll try to hold on to some time for question and answer at the end. But I'd love to jump in and introduce you to our wonderful panel here today, who you all just happen to sit in order, so thank you. So Dee Dangaran is the Director of Gender Justice at Rights Behind Bars, which is a legal nonprofit that sues prisons, jails, and immigration detention centers to challenge their cruel and inhumane conditions of confinement. Dee specializes in using litigation and other forms of advocacy to help incarcerated trans people access necessary gender-affirming care. Dee also serves as a co-chair of the National Trans Bar Association. Thank you for joining us, Dee. Next to Dee, we also have Dee Farmer, who is a legal expert, consultant, and trailblazing advocate at the forefront of both transgender and prisoners' rights movements. Notably, in 1994, Dee made history as the first transgender plaintiff to bring a case before the United States Supreme Court in Farmer v. Brennan, which fundamentally reshaped the legal landscape surrounding prison assault cases. Dee is also the founder and executive director of Fight for Justice, an organization that supports currently and formerly incarcerated people through advocacy, education, reentry services, and legal referrals. And just as a side note, I mentioned to one of my colleagues earlier that I was going to hear from Dee Farmer, and she was like, the Dee Farmer? And then she came to your keynote earlier, so thank you. We're all excited to have you here. And then we have James Esseks, who serves as the director of the ACLU's Lesbian, Gay, Bisexual, and Transgender, Queer, and HIV project, where his leadership has been instrumental in advancing the rights of LGBTQ+ folks across the United States. During his tenure, James has acted as counsel in multiple landmark Supreme Court cases concerning LGBT rights, including, amongst them, Bostock v. Clayton, Obergefell v. Hodges, United States v. Windsor, Gavin Grimm v. Gloucester County School Board, Masterpiece Cake Shop, and Masterpiece Cake Shop, among many others. So thank you for joining us, James. And last but not least, we have Whit Washington. Whit is a civil rights attorney at the Transgender Variant Justice Project. They are a dedicated advocate for transgender, gender diverse, and intersex persons impacted by the carceral system. Whit previously served as an Equal Justice Fellow, during which time they created the Project for Transgender Incarcerated Survivors at American University Washington College of Law's Center for Human Rights and Humanitarian Law. Thank you so much for joining us. So there are many directions we could go when given a panel topic of queer rights and the law and its limitations. One place we decided to focus that is important for many reasons that the panelists will get into is queer rights in the criminal legal system. And the keynote earlier addressed many important issues of folks when incarcerated. We will touch on some of those and go a little bit deeper on some of the legal strategies being used to challenge issues faced by queer and trans folks when incarcerated. But we're going to zoom out and actually look at other aspects of the criminal legal system as well, including policing and reentry issues. And so jumping in, let's begin with some discussion of how queer and trans folks come to be overrepresented in the criminal legal system in the first place. And in keeping with this colloquium being about the past, present, and future, we'll start with a little look back at the past, briefly some historical context on the criminalization and policing of queer and trans folks. Whit, I'm hoping we could start with you. I know you've done some research on this topic. Just how far back does this phenomenon go, and how intertwined is it with the U.S. history?
Yeah, so my research sort of generally is looking at the conversation between constitutional rights, criminal law, oppression, sort of as part of that, in the U.S. economy. And so I go as far back as the 1600s, specifically talking about Bacon's Rebellion, which was an event where poor white folks and poor black folks had actually come together under like a very not great cause, but actually like very closely overthrew sort of like the ruling wealthy class. And it is after this that we see like a lot of movement in terms of the codification of race-based slavery. I think that some folks might think we're talking about LGBTQ issues, specifically trans issues. Why are you talking about race? And I think that it is inextricably linked. When you look at the use of the criminal legal system to criminalize black folks and replace the slave economy in the U.S., you see that model of criminalizing identity is very similar to what is used today to criminalize transgender individuals. When you talk about the black codes that came after the Civil War that criminalized black identity to replace that slave labor force under the exception to the 13th Amendment, a lot of those laws were vagrancy laws, walking while black. I'm sure folks have heard walking while trans, laws that criminalize existing in a way that is not conforming with the main powers within society. So really talking about the ways in which the criminalization of trans people is rooted in that history of the criminalization of black people. When we talk about, like, one of the main ways that this happens, specifically with black codes, is talking about vagrancy laws. In vagrancy laws, it's the act of wandering from one place to another with no apparent means of financial support. So again, what the last panel was talking about, this criminalization of poverty, while also creating a system that creates and exacerbates poverty within oppressed groups of people. And so I think the sort of most important piece of this, as we're talking about the rights of trans people, we have to be very intentional and thoughtful about the ways we think about the criminalization of people, of non-normative people, because that's sort of like the impetus of why trans rights are being targeted right now.
Throughout our conversation today, please, all panelists, feel free to jump in and discuss with each other the ideas that are raised. I will jump in and take moderator's privilege to ask plenty of questions. Don't worry, but so I will try to take a beat if you have any responses. If not, I've got a question. Great. So fast forward to the 20th century. I'd love to hear a bit about the types of laws, and Whit, you talked about this a bit with walking while trans laws. But what laws have been used to criminalize queer folks, and what has become of those laws of the 20th century? And James, we'll turn to you.
Sure. So I'd like to just talk about two things, two criminal provisions that have been a significant problem for the LGBTQ plus community during the 20th century. One is sodomy laws, and the other is laws barring cross-dressing. Before 1962, every state in the country had a law that criminalized same-sex intimacy, and they are gone now. It was a long journey. Started getting rid of them. Actually, through some sleight of hand legislation. The model penal code was updated in a way that just took out the sodomy provisions. And then some states started adopting the new model penal code. And that's the only way that we got rid of the first good number of criminal sodomy laws. So it wasn't some enlightened reform movement. It was some reformers within that body that drafts the model penal code that managed to find a way silently within the system to enact some reforms. Obviously, there was a U.S. Supreme Court case in 1986 challenging the constitutionality of the criminal sodomy laws. Bowers versus Hardwick, our side lost. And in 2003, in Lawrence versus Texas, the court overturns that and takes down what at that point were just 13 state laws that still existed. And the cross-dressing laws, these were usually not at a state level, but often at a city level. And they were all over the place. They were laws that said it was a crime of various different dimensions to adopt to wear clothing of the other sex. And one of actually the ACLU's first, actually I think the first trans justice case that we can find in the ACLU history is from 1967, where the ACLU of Southern California represented a person named Sir Lady Java, who was a performer in bars in LA, who was a crossdresser and I think was a trans person, and was barred from performing because of a local LA law. And the ACLU tried to sue over that, but we needed the bar to sue, and the bar was not willing to take on the risk of suing. So, but Sir Lady Java made a lot of noise in a grand way around that. So those provisions are largely gone, except, and we'll come back to this, they are showing up again in drag bans. But I think, Dee, you had some other stuff that you wanted to cover in here?
Yes, just jumping in with your point about the bar. So I was a research assistant on Anna Lvovsky's book called Vice Patrol, and it looks at the policing of bars that hosted gay, queer, fairy clientele or patrons or performers from the 1910s to 1960s, right before that era. And in that era, what I was looking at really closely as editing the book was the state liquor authority decisions. And Professor Lvovsky is very interested in the way these agencies treat police officers as experts on what queerness means and on what spotting or identifying queer people might entail. And they're looking at, limp wrists and the type of dress that people are wearing, and there's battle over, well, is it just like an Ivy League dress code? Like maybe they're just Ivy Leaguers, they're just Yalies, compared to actually queer fairies. And so reading case after case from this era made me claim the term fairy. There are the radical fairies, but I just realized that what the fairies did in these spaces was really queering and questioning how people perceived gender. And they weren't the performers on stage. They weren't necessarily identified as men, and they weren't trans women. They were something in between. You can see in this archive the existence of these gender nonconforming and non-binary figures that were deemed fairies pejoratively. And by reclaiming that term, I'm trying to correct a really horrible part of our history and show that this kind of expression, this gender expression and gender identity, has existed for these years. But what's really horrifying is in Hawaii right now, you have the same kind of target, and I'm from Hawaii, and there was a targeting of a local gay bar and club using very similar means. It's police who are in plain clothing, going in and trying to identify anything they can to bring the establishment down. And there's a bill that's on the table now related to liquor licenses. And you see this gay bar that otherwise was, pretty apolitical, now posting political things on their Instagram page now and trying to get their patrons to be more politically active. And so we are very deeply tied to this long history. And I think all of the bans on what it means to be trans today that we'll get into soon, or to be a drag performer today, are linked to this exact history from earlier in the 20th century.
Thank you, Dee. And that's a perfect segue to the next question that I have for you, which is, it's been 156 years since the enactment or the ratification of the 14th Amendment, about 20 years now, or 21, since Lawrence v. Texas. So a lot has changed in these time periods, but perhaps not as much as we would like to think. And so what do you see as, causes of disproportionate criminalization and targeting of queer and trans folks, and what are advocates doing in response to that? And Dee Farmer, as an advocate working closely with incarcerated trans folks, I'd love to start with you. We haven't heard from you yet.
What I've seen in my research is
Test.
yeah. Okay, I just bring close. Thank you. What I've seen is that main society has, as transgender issues have become more public or more focused in the and publicized in the world, that the mainstream society has felt that they need to respond. For example, with the bathroom bans, trans people has always used female bathrooms, but as the transgender population has become more widely known and accepted in society, then the mainstream has felt like they have need to fight back. But they're fighting back against something that has always existed, and they don't want to acknowledge that. They are acting like trans people, just came to planet Earth when we've always been here. But the trans incarcerated people that I talked to or have interviewed that are in prison, they feel like they are targets they are singled out when they are walking down the street for, harassment, and eventually they are arrested. But really what happens is that when they go to prison, that they never really get the care and treatment that they need. And so when they get out of prison, they are returning to the same community, and the same police officers are harassing them, and they end up back in prison. And so it's just a constant, revolving door.
Thank you. And I think you're speaking to many important themes there, including the criminalization in under-resourced communities that aren't getting the care and the help needed to stay out. And I think we'll talk more about that later on. I want to hear more about your reentry work. But before we get there, going through the many problems of the system procedurally, starting with targeting and then or criminalization, I would love to hear from other panelists some of the other drivers that you're seeing of what is leading to this disproportionate number of queer and trans folks ending up behind bars and in those situations.
As part of CLE credits, I think folks may have seen the article, the discrimination to criminalization pipeline. So talking about the ways in which when folks are pushed to the margins of society, in a society where poverty is criminalized, otherness is criminalized, there is a tendency for folks on the margins to be sort of like forced into a criminal legal system. And so like looking at the ways in which our oppression as society is violence, not only on an interpersonal level, but socially, of like putting people into a prison system. When I started doing my research, one of the pieces that sort of like got me going down this rabbit hole was this conversation around individuals who engage in consensual sex work on the outside can be put in prison, and then once they're in prison, if they experience sexual violence, it's not super likely that they're going to get justice or have that acknowledged, and it's violence often done by the state. And so I started having this question of like, what is crime? If it's not about negative acts happening to people, it has to be something else. And that's how I ended up at this like economic piece of what is the role of the economy, and how does the economy and specifically white wealth benefit from the discrimination of individuals. And when you look at the money that states and the federal government make off of slave labor in prisons, it's not confusing why they're so popular. The ACLU recently released a report called Captive Labor, and it actually like counted how much money states are making. And I think California, just like the state from prison labor, was making something around like $24 million, or no, I think it was like $263 million from slave labor. And so when we talk about the impact of discrimination and oppression in our country, again, it's not that interpersonal piece only, but it's also there are very serious economic implications for people who are not part of the powerful white patriarchal cis heterosexual group of folks.
So I want to jump in and say, Molly, I think the thing you posed is like, well, what's driving the incidence of criminalization of queer folks? And what I'm seeing now is, I think we've talked some now about ways in which there are disparate effects on LGBTQ people. What I'm seeing, though, is that there's a broader problem that's getting worse, which is that there's an increasing express criminalization of being trans. And, it's showing up in a bunch of the new state laws that we're reading about and fighting against. criminal laws about using the restroom. Some of the restroom restrictions in the country are not criminal laws, but some of them are. Florida has a law right now on the books that is a criminal law. It's a criminal trespass law. It says that if you're in a restroom that doesn't match the gender marker on your original birth certificate, and somebody asks you to leave, and you don't, that's a crime, and you can be arrested for it. Now, they haven't arrested anybody in Florida yet on this. We're waiting because we want to sue over it. But it doesn't matter. I mean, like it is obviously a problem to have it be a crime, but it is terrorizing people in Florida. That's what it's designed to do. And we're sitting here waiting for some greater level of enforcement in order to be able to sue, which is a whole separate problem with the legal system we have. Arkansas last year almost passed a similar, actually a worse criminal prohibition in the restroom. And there are laws that have been proposed in some other states. None of them are moving yet, but I'm very worried about new criminal laws in the restroom context. There are a series of states that have criminal laws on the books right now in the healthcare context. Idaho, Indiana, Alabama, and I think Oklahoma, but I'm not sure, their healthcare bans are criminal bans. In Alabama, it's a 10-year felony. I think in Idaho, it's a 10-year felony to provide health care to adolescent trans folks. In Indiana, there's a very broad aiding and abetting provision to their criminal law. So parents or anybody else who gives advice to trans folks in Indiana about where to go in another state can be prosecuted as aiding and abetting the provision of criminalized health care. We are just going backwards on this issue in so many ways, and the idea that there are new criminal penalties here is just astounding. We mentioned earlier drag bans. A bunch of them are criminal provisions saying that it's a version of lewdness in public or obscene behavior in public, and they simply defined obscenity to include, in some cases, just being trans, just being a person who was assigned one sex at birth and is presenting in another according to a different sex, and being on stage, and that is enough to be guilty of a crime in some of these states. And lastly, we're seeing some criminal laws in the identity documents context. So Florida, it's not a statute yet. It's simply, at this point, it's a memo from the Department of Motor Vehicles in Florida, but it says that use of a license with an updated gender marker is fraud, and fraud is a crime in Florida. Again, they have not charged anybody yet, but there's a statute that would make this into a law, not just a guidance from the DMV, and that legislature is just wacky enough to pass it. So, and I worry that this is what's coming in addition. So we're not just in a place where there are a bunch of different ways in which the queer and trans communities are disproportionately affected by discrimination and by laws and systems that weren't designed for us. We're increasingly in a place where they are very expressly making criminal laws that require discrimination against queer and trans people in a way that we have not seen for decades, and it is terrifying.
Can you hear me? Okay, great. I don't remember, James, when I interned for you, we spoke over the summer in a great mentorship conversation, and you had like a 4-step or 4-tier vision of equality and where we were and how we were regressing. If you remember the step, I've racked my mind. I can't find the notes that I was taking from that conversation, and I've racked my mind trying to remember it. But you were right that even in 2019, we could already see the issue was that we were regressing. You remember what your thesis on that was? Yeah.
Well, so I mean, here's, and I'm not sure that this is original to me, but for me, it has been a helpful construct that civil rights movements, I think, go through a progression, and it's not necessarily linear. But the first thing you got to do is you have to get rid of laws that require discrimination. Slavery is that kind of law. Laws that say that women couldn't, be in certain professions or serve on juries. That's part of it. Jim Crow segregation laws. Those are laws that require discrimination. You got to get rid of those first, and then in step 2, you've got to get laws that bar discrimination, non-discrimination laws in various different contexts. And you need to get rid of the laws you need to do step one, getting rid of the laws that require discrimination, and get the laws that ban discrimination. But we've been in a place in this country, let's say on race, where there are few, if any, laws that still expressly require discrimination, and there's been bans on discrimination based on race in this country for decades, and it's improved some things. I'm not here to say that it made no difference, but life on the ground for a whole lot of people of color is really pretty terrible. And so discrimination is still a reality. So the third step is you've got to work on lived equality, and that is much harder than the first two steps. The scary thing about the moment we're living in now is we are going backwards because we are getting more new laws at step one that require discrimination, that are the kinds of things that should by rights be, part of our deep, deep, dark, distant history, and they're part of our present and our future. And so it is just a marker of how terrible and how sort of off the rails our society has gotten.
Yeah. Thank you for that. I think it's super helpful as an organizing tool for what's happening. And I think a lot of the trans and non-binary community is mourning Nex Benedict right now and tying that killing to the discrimination ban at that step one level in Oklahoma. And it doesn't even need to, I don't know if it's criminalized either, but things don't need to be explicitly criminalized in order for these extremely abusive outcomes to occur. And so in the prison context, for example, not a facility need not have an anti-trans or gender-affirming care bill in the state passed or in the regulations for officers to decide, I'm not going to give this person what they need. Because the societal context of anti-trans discrimination seeps into how they're treating people on a human level. And so they're naturally going to just bring that transphobia or deliberate indifference, whatever you want to call it, they're bringing it into how they're caring for people or not. And so I think an important historical piece to this is there was an opportunity in our LGBT politics past for a trans-inclusive Employment Non-Discrimination Act, right? That step two level. And because of political decisions or compromise decisions or strategizing, what may be termed strategizing, organizers on the cis, gay, and lesbian and bisexual front opted to leave out trans people from their act and went forward on a bill that didn't pass anyway, trying to secure rights for cis gay folks. And I think that because we've seen this piecemeal effort for the LGBT community moving forward, it's like the first wave from the 80s through 2015 with Obergefell, right? And even after that, we still saw individual agents. What was her name? Kim something.
Kim Davis.
Davis. Yeah. On that individual level, preventing someone from getting what they're now legally obligated to have. But I do think that we cannot deny that cisgender gay people who wanted to get married in homosexual relationships, bore the brunt of a lot of shit for a while trans people were also bearing the brunt of their shit. And in a way, if you have this formal legal equality happening now and we've changed hearts and minds for queer relationships, but not for trans people because they were not a part of our agenda and we were trying to do queer assimilationist or gay assimilationist work instead, now it just makes sense to me that the people who are going to be bearing the brunt of the next form of violence and are receiving the intensive backlash are the trans people who now seem to have finally had their day. And you have, simultaneously in 2014, headlines saying this is the trans moment, the trans turning point, the trans tipping point, and now 10 years later, some of the most anti-trans work happening by legislatures. And so I'm just very worried about what I'm inheriting, and it does feel it's helpful to remember that it's not linear, because I do feel like we are on a treadmill. And it's scary, but I think that's why it's helpful to speak with Dee and know we are moving forward, and we've come from a circumstance where we had nothing, and now it's just a matter of we are winning, and we have to remember that this backlash is because we are winning, and it is because we have changed hearts and minds, and we are not going anywhere, and they're scared about that. But it makes for, we are constantly grieving as well because of the backlash.
I'm going to jump in now with a CLE code. So for those of you getting CLE credit, the first CLE code is rights for all. It's spelled out with no caps. So no capitalization. Spelled out, spaces where there would be spaces, for is a full word. And for those online, I don't know if someone's able to put it in the chat or if that's part of the plan. Oh, you're not allowed to. Okay, clearly I don't really know how the rules of CLEs work, but rights for all. And if folks, yeah, I guess that's all we're allowed to do, I guess. Okay, you can't ask me after. You got to get it now. So sorry for that little break. But I would love to move us along to talk about, and we've touched on this a little bit so far, but incarceration and conditions of confinement. So in addition to heightened criminalization leading to disproportionate numbers of queer and trans folks entering jails and prisons, and a frightening number of new laws that are potentially going to increase that further, there is ample evidence of pervasive abuse and discrimination against queer and trans folks when they are behind bars. Horrendous conditions of abuse of incarcerated people is obviously not limited to just queer and trans people, but what do you see as some of the unique or specific ways that queer and trans folks are harmed in prisons and jails? And what are those strategies and tactics that you and your colleagues, comrades are employing to try to fight back against those abuses?
So I'm lucky to be with some of said comrades and colleagues on this panel, and excited to hear, our various ways in. I'll just start with some numbers. In 2020, according to NBC News, there were 4,890 trans people incarcerated in state prisons across 45 states. Only 15 of them were reported as housed according to their gender. And so one, I think, key issue is housing, because with that lack of, I want to call a gender-affirming housing placement, stems a lot of violence. And so in 2021, there were 1,200 trans people in federal prison, and the DOJ found in 2012 that 40% of trans people in prison have been sexually assaulted, which is 10 times the rate of the general prison population. And, I came into this work through previously thinking I would do some form of domestic violence work before I realized exactly how carceral that work can be, and see a lot of similarity between, if you're thinking about survivors, some of the most daily survivors of sexual assault in this country are in prison, and they are trans femmes or even queer men in prisons. Working on rape as a feminist means working on prison abolition. I just can't tear those apart. And so safety and housing are two of the key issues for intervention, and a third is gender-affirming care. That includes social transition items, such as access to commissary items or special items that aren't accessible in the commissary, to allow one to have the gender expression that aligns with their gender identity. And that also includes access to hormone therapy, gender-affirming surgery, laser hair removal, and any other form of therapy as well, and any other form of medical care that folks need. Am I missing anything?
I would say mental health. I think that what I have found is that trans incarcerated people, while they are able to get gender affirming care if they are able to, or even if they are able to get gender consistent housing, that they never get the mental health or life skills training or treatment that they need, that would really propel them to the next level of being a successful trans person. And so when they do leave prison, they are pretty much in the same situation that led them into prison in the very beginning, because the entire time that they are in prison, they are faced with similar obstacles that they faced in the community, you know, the pressure, the disrespect, the isolation, the discrimination, and, you know, they never really get the mental health treatment that they need. And that's because in prison, the Constitution only requires them to give you mental health treatment if you have a serious diagnosed psychiatric disorder, and they don't consider that kind of treatment, you know, warranted. And so that, I think mental health is the only thing I would have added.
Great. And so I think that's also really important. There's an example I'm working on right now in Georgia. There is formal discrimination occurring inside to prevent people from accessing programs if they are trans. In Georgia, there was allegedly, I haven't seen it myself yet, a memo written by the commissioner of the Georgia Department of Corrections and a coordinator of their transitional centers, which are these essentially halfway houses that are still extremely carceral. But they allow people to go in and out from the facility, earn an income, and have that saved while they're working inside, a much larger income than they can get in any prison labor job, and apply to jobs and go to job interviews. And these transitional centers do not allow trans women who are in men's facilities that are not transitional centers coping to be housed in them, because the warden does not want to bring those transition centers up to the standards for PREA compliance by accommodating the showers and allowing for some privacy. And so because it's safer to keep them in the prison than in the transitional center, they're not being allowed to have access to these other reentry and rehabilitative possibilities that would make it much easier for them upon reentry to not recidivate. So the things that I can do, that's the case example, right? So with something like that, there are obviously some litigation potentials and some other forms of advocacy that anyone who's interested in this would be looking at. And so the lowest level intervention is something like a phone call or a demand letter directly to the facility or to the commissioner, trying to articulate the unconstitutionality of what they're doing, convince them, persuade them to do the right thing. Maybe you take a stronger stance and show why they ought to do it, or you will sue. If you think you can. I think to wave one of those letters around, if you're not going to follow it up with a lawsuit, could just lose credibility and they're never going to take your letter seriously. But if you actually give this kind of scare letter or demand letter, it might lead to change. You can get many people doing that, so build a movement around it, get some media attention, and build community power to see that that's a problem and draw attention to the issue, and maybe that will add more pressure. Though locals in Georgia have informed me that Georgia Department of Corrections does not take well to public pressure, and there's always the risk, especially in these states, of solidifying the anti-trans discrimination because that's actually politically popular. And so you have to tread very carefully there. And that leads to me to litigation as the kind of final step, if nothing else is going to change it, and it's a harm that we know is meritorious. There are many claims for this one. It's a Fair Housing Act claim, an Americans with Disabilities Act claim, which I'll come back to later, possibly also an Eighth Amendment claim, for lack of access to programs that others have that would go to accommodating their gender dysphoria, like the prison shower protections under PREA. And so I think that if we bring litigation in a case like this, the goal with the injunctive relief is to change it for everybody. But often with litigation, a downside is that the facility often settles out and gives something just for the individual and doesn't make lasting change for all. Or the person, especially in this kind of context where they're about to be released, and that's why they're seeking this, the person is released and the case is moot. And you can't seek the injunctive relief that you're trying to get for everyone else because the person is now in the free world. And so it's kind of constantly changing, and departments of corrections are slimy. They're good at doing what needs to happen to ensure they don't actually be held accountable by the courts. But I do still think that the courts are a backstop, and we have to bring these battles when we feel like we have no other option, because that's what we're here to do. The harm reductionist part of being a lawyer is stepping in when it's time to bring the lawsuit. And I think that's what the movement lawyers are here to do.
So let's get specific here and make the audience earn those CLE credits. What laws specifically are you litigating under when you're challenging these conditions of confinement or incarceration-related issues?
So this is James. I'll jump in. A lot of the work that we do in the criminal legal system, and particularly in the carceral settings, work is Eighth Amendment work. Sometimes it's equal protection work. And I just sort of piggyback on what Dee Dangaran was saying, which is like Dee and Dee both named a series of contexts where there are problems. Litigation can make a big difference in a lot of those things. One of the things that was mentioned was placement in women's facilities. We've had two cases that are either going on. One's going on right now. One is just concluded. One on behalf of a person named Cristina Iglesias was against the Federal Bureau of Prisons. Her first issue was placement. She was in a men's facility. She shouldn't have been in a men's facility. And it took a while, but they did it. They moved her to a women's facility. Kanautica Zaire Brown is incarcerated in the North Carolina state prison system. Her first issue was also a placement thing, and North Carolina has finally put her in a women's facility. So you can make a difference. One of the things that's a challenge in these kinds of cases is you often end up making change for one individual and not for everybody. And we may get a court ruling that establishes a principle of the law that should apply to other folks, and in theory it does. The thought, you would think that it would mean that the facility would, or the state prison system would just start complying, and they don't, because that's just not how these systems work. And so the reality is you have to go back and forth. But one sort of model for thinking about impact here is that sometimes getting one or two of the first people to get something from a prison system can make a big difference. I think that's true for the placement issues. I think it's also definitely true for healthcare access issues. The same Cristina Iglesias plaintiff who sued the Federal Bureau of Prisons, her first issue, as I said, was placement in a women's facility, but her second issue was surgery. And she had been asking for surgery for many years, and many different prison healthcare providers had certified that she had extreme gender dysphoria and she needed surgery. And BOP was just refusing to provide it. We brought a lawsuit on her behalf. And thanks to a federal district judge in the Southern District of Illinois who learned a lot about this situation and got super pissed off at the government. Cristina Iglesias has gotten bottom surgery and facial feminization surgery on the federal government while in prison and has just gotten out. And seeing the process of trying to get the bureaucracy of BOP to actually move this thing along, even when the lawyers at DOJ who were defending them were begging them to make this happen so that the judge wouldn't get more pissed off than she already was. And even in light of all of that pressure, seeing how slow and how complicated and how troublesome it was to get the changes to happen, I'm not saying that I come out of this thinking, okay, the next, we have not greased the skids for everybody who comes after her, but it's got to be a lot easier because the power structure within that department actually now understands more about, A, understands the need in a way that they didn't before, and B, they've had somebody go through the process and they've figured out what the various different pain points are, and they've addressed some of them. And that's got to mean that it's going to be easier for some, at least some of the people coming down the road. And the problem here is you have to keep doing this and doing this and doing this and doing this and doing this if you're going to actually make a difference on the ground for folks. And that requires incredible amounts of resources.
One of the other avenues that I think is like woefully underutilized is looking at administrative offices within the executive branch. Dee mentioned a Department of Fair Housing complaint. In California, we've seen folks try to go through the Fair Housing Department within the state to try and get people transferred. So doing a discrimination claiming under that. The Prison Rape Elimination Act also, in Maryland, they went to an administrative court. And one of the issues that Dee Farmer was speaking about before, the Prison Litigation Reform Act, which creates a lot of barriers to people being able to file claims. In that case in Maryland, because it was an administrative court, the PLRA didn't apply. Dangaran was working on a claim, a human trafficking claim, not for trans individuals, but for cisgender women in a federal facility using a human trafficking claim. Again, another way to sort of circumvent the PLRA. And so I think when we talk about barriers, it 100% is the Prison Litigation Reform Act. And I think that there's a lot of room for creativity for the next generation of attorneys coming up to think about different ways to address these issues and overcome a lot of these barriers that people are facing. One other thing that I did want to say too is when we're talking about advocating for people and even the creation of a positive law is we also have to be mindful and think about the ways that law can be weaponized against our folks. So the Prison Rape Elimination Act, we see it weaponized against folks who engage in same-sex sexual relationships so that solitary confinement is an issue with our folks inside of being sent to the SHU because they're engaging in consensual sexual behavior. And also when talking about advocating for people inside, thinking about potential retaliation. And so to me, I feel like part of that shortcoming of the law is that this work really takes community and it takes a lot of people being able to show up and support one another. And I think that there is like an interpersonal piece to this work that the law can't address. And we see that as we talk about implementation of laws, specifically talking about SB 132 in California, which allows people to be placed based on where they feel the most safe. The way that the facility has implemented it is horrifying and very dangerous and has been weaponized. And I think that there are things that are talked about within this space as like, this is the best way to do it. But I think we also need to be mindful of the reality of prison space and that the law can't always touch the horror that is happening. And how can we come together to overcome that?
I think when I was at the PREA congressional briefing that Dee spoke at, I asked her about PREA and also Section 1983, and she can just explain Section 1983 so well. So I wanted to ask her if she could explain that cause of action.
Sure. Section 1983 allows for incarcerated people. It doesn't particularly apply only to incarcerated people, but it applies to civil rights violations in general. But it allows for incarcerated people to bring a claim for a violation of their constitutional rights in federal court, whether they're in a local jail or a state prison or a county jail. They can file a lawsuit claiming a violation of their constitutional right under Section 1983. Of course, the PLRA, as Whit said, has put various limitations on that to decrease the inmate ability to bring those suits. But I wanted to point out what you had said, James. When I was in the Bureau of Prisons, or actually went to the Bureau of Prisons many years ago, they had a policy that didn't allow for hormone treatment. And I filed my own case, and I probably filed 50 other cases on behalf of other trans inmates seeking hormone treatment. So I think that it is important for us to just keep pushing the issue forward, each time. You got it for Christina. We just have to keep doing it until they realize that this is the right thing to do, and then it becomes normal. The Bureau of Prisons took decades before they actually changed their hormone policy, that now it's almost a matter of course, if you have the diagnosis, that you're eligible for hormones. So I think it's just a matter of keep pushing the issues forward.
Yeah, and because of the work of Ashley Diamond and her lawyers at the Southern Poverty Law Center and the Center for Constitutional Rights and other firms, even in Georgia, where we're getting a lot of pushback on a gender-affirming surgery case, hormone therapy has been granted. There are some issues still, and there are delays for many folks, and some facility-level staff who aren't giving people what they need and what they know the state has literally put in their regulations. But it's been a win since 2015 that it's generally accessible where there seemed to be some kind of ban before. I wanted to add that Black and Pink Massachusetts, after some work that I was doing with them during my fellowship, learned of a need for single cell housing for trans people. So instead of transferring to a women's facility, some trans people are worried about what transferring to a women's facility would be like for them before they're able to transition, and they're scared about more targeted retaliation. And I think it's a fair concern. And so, just like in the previous panel, the point was made that there's not a singular community of any racial group, or there's not a trans community singularly. I don't think there's a trans community inside. I think every trans person has different needs. And so for this person, having the option for a single cell has been her number one request, and the facilities have refused to give it to her. And so Black and Pink Massachusetts organized to put language in a bill seeking, because there's already a robust Criminal Justice Reform Act in Massachusetts, and they understand the needs of trans people. This is just a slight addition to allow single cells for those who want it to be a part of the understanding of what people with gender dysphoria might need to be safe. And so trying to be very responsive and be connected to people on the inside would inform whatever strategies that we're doing, which leads me to our last kind of theory or cause of action, which has been growing for a while now over time, and it's bringing an Americans with Disabilities Act claim. The folks who really have focused on this have been Jennifer Levi at GLAAD and Kevin Barry, who's the dean at Quinnipiac Law. And they brought it in the employment context first in 2017 in Blatt versus Cabela's Retail. But then in Doe v. Massachusetts, there was an ADA claim alleged, and that was in 2018. And finally, the Fourth Circuit affirmed this theory in Williams versus Kincaid just in 2022, and the Supreme Court denied cert in 2023. And so it took me a long time to get on board with this claim, I will say, and I think there's a lot of pushback to it because folks don't like the thought of trans people being disabled. But gender identity disorder and gender dysphoria are two different things. And gender identity disorder was removed from DSM-5 and replaced with gender dysphoria, which focuses on the distress, the significant distress that some people with gender identities that are not their sex assigned at birth experience. And so because gender dysphoria is different from gender identity disorder, the legal argument that has to be made is that the exclusion in the Americans with Disabilities Act of gender identity disorders does not apply to gender dysphoria. And so it's a pure textual analysis that the Fourth Circuit upheld. And it's worrisome to think there will be a circuit split because that's, Justice Alito, joined by Justice Thomas, issued a statement when cert was denied, saying that they would want to reach this issue and they're worried about this. But I don't think that's reason to stop bringing the claim. I think that the claim is a strong one. The ADA is an easier standard to meet than the Eighth Amendment. You don't need to show subjective deliberate indifference in the same way. And so if someone has a gender dysphoria diagnosis and they're not being provided access to reasonable accommodations that would go towards that diagnosis, they have a claim. They really don't have to show the high standard of deliberate indifference that others do under Eighth Amendment. Another thing that many protection and advocacy organizations are doing, though, besides bringing advocacy based on gender dysphoria, is they're just looking at any other form of mental health disorders that someone might have, such as anxiety or depression, and using that as a reason to get in the door, to visit them at their cell, to ask for what they need. And so thinking about the disability framework for trans people, but not just based on gender dysphoria, is another way that we can expand our advocacy here. And so if everyone in this room or everyone on Zoom joined a PNA and pushed them to do more prison work and pushed them to think about gender dysphoria and other things that trans people may be diagnosed with as their way of doing the work, we don't have to be waiting for causes of action, waiting for the right moment to sue and be fearful of whatever might happen on circuit splits. We could just be doing internal work. And this is happening in some facilities. And sometimes if the facility doesn't listen to what the PNA says, the PNA can decide if they want to bring an action. But I do think that we have to be very intentional about moving on all fronts at once right now, because we know our comrades and friends and community on the inside are suffering daily. And my client, even with, I have a client in Georgia we've sued recently, and even with the pending claim, her gender dysphoria has exacerbated as she's waited for the things that she needs. And so her suicidality has increased, her desire to self-castrate has increased, and it's urgent. These are urgent needs that the facility is just digging their heels in. And I really think that the ADA is an option for us to strongly consider and ask people about, and be in conversation with your clients about if you're working with trans people, because they might not want to bring that claim. But if they can get on board with it, then I think it's one that they ought to be able to.
Dee, can you just explain what a PNA is?
Yeah, so protection and advocacy organizations are interesting because they're kind of an arm of each state, and they have the opportunity, kind of like a public defender's office, to sue the state if they wanted to, but they have more access than any other kind of standalone civil rights organization does, where because they're working with the state and they're upholding the state's obligations under the Americans with Disabilities Act, they can do things out in the free world, they can also do things in prison. And so we have colleagues who, there was an Equal Justice Works fellow, his name is Danny Waxwing, he worked at Disability Rights Washington, and he told me about how he could just visit trans people at their cell because of working for his PNA, which is phenomenal. Like it's a really amazing power. And so if we could have cell visits for all of our folks, that would really change the game.
Thank you. It's heartening this is a heavy conversation in a lot of ways, but heartening to hear about new avenues being explored to push back on some of these abuses, and also to see the cross-pollination of various, the disability rights movement and the LGBT movement. I think it's really powerful to see. So thank you for sharing that. Hoping we can fast forward to discuss some of the issues faced by folks when released from incarceration. I know, Dee, this is something you have done quite a bit, or Dee Farmer, is something you've done quite a bit of research and advocacy work on, and wondering if you can talk to us a little bit about that.
Sure. So, as Dee Dangaran was saying, most trans people, as they get close to release, they are not allowed to go to halfway houses or reentry centers, but they're released directly into the community, and they don't have health care. They don't have home. Most of them don't have homes to go to, and they don't have resources, and so they end up in shelters, and they pretty much end up, back to sex work or back to criminal behavior, back to using drugs. And it really stems because the entire time that they are in prison, they are not getting the programs. They are not accepted and pretty much rejected in employment, vocational programs, even drug abuse programs. Even if the court orders that they do a in-prison residential program, the prison can decide that they are unfit for the program. And so in the residential program, drug programs in the prison, you don't find trans people, and you don't find them in quality jobs such as in, Unicor or, jobs that provide training that will help them get employment. You find them mostly in the units doing cleaning stuff. And the only reason they give them those jobs is because they have to have some kind of job. And so, they can't, when you're not going to come home and get a job, paying you that will help you survive based on what you learn how to clean in prison. And so it just becomes a revolving door of, homelessness, drug abuse, and, oftentimes it leads to suicidality, and just, various abuses.
So for this exact reason, one thing that Black and Pink National and Black and Pink Massachusetts created were houses for folks, for trans people specifically, after reentry or whenever they might need it. The Alexia Norena House is in Nebraska, I think in Omaha, and I'm not sure if it's still open, but Black and Pink Massachusetts for a time was running the Leiden House in Massachusetts. And so if there are, community centers or spaces that are thinking about what they can do, or if there are large donors who are thinking about ways they can make a real impact, providing housing and securing housing for people upon reentry is huge. Dee and I are in coalition with folks in Georgia who give people just mutual aid when they're reentering as well, because that is a necessity. There's a lot showing that access to finances allows you access to your hormone therapy, a roof over your head, safety, and so to prevent someone, one of my she's not a client, someone I've been working with has been in and out I think 2 or 3 times, and she's very worried this time around because before she was not on HRT, because of her advocacy on the inside, she started HRT while she was on the inside, and now she has that additional cost to try to keep that up while she's out in the free world, and so she's very worried. But finding these kind of mutual aid organizations that will help people upon reentry and supporting those orgs locally is a big thing that we can all do to take care of people.
Thank you. So I have a couple more questions that I would love to ask you, but I want to be mindful of time, and I'm sure folks who are here in the room and also those who are joining us by Zoom also have questions. So I want to open the floor for other questions, and if we have any time left, I'll come back to mine.
We have one question on Zoom. The question is, In a world of scarce legal resources and scarce public attention and attention span, how do we focus our attention and capacity on those cases most likely to help the most people?
Well, I don't know how you distinguish a case that will help the most people. You actually never know where a case will lead and what the decision in the case will be. So I really don't know how you distinguish a case that will help the most people. I think that, that we all as advocates have a role to play. And I think that, you just need to do the best that you can with the cases that you have and, hope for the very best. But I really don't know how you would distinguish a case that would help the most people.
So I appreciate the question, and it's one that when I was in law school particularly, I was grappling with when choosing between, say, direct legal services role or an impact litigation role, with the assumption that impact litigation was helping, quote, the most people, and direct legal services is pulling people out from the bottom of the stream one at a time, and that leads to burnout, and it's not changing the system, and therefore not helping everyone. It's not helping, one could even argue that it's not even helping the person that you're pulling out. And that the time and resources it takes to do an individual case is zero sum with any, other case you might be able to do. I think that to Dee's point, the reason I have chosen, and I'm glad to be in conversation with James about this, the reason I've chosen to do the work that I do now is that movement lawyering and prison litigation has taught me that any case could be an impact litigation case. That there's kind of an audacity to thinking we get to decide as the litigators what an impact case is. We get to decide who our plaintiffs are, sure, but we don't know what's going to happen on appeal and what the Supreme Court will take. We can try to tee it up really nicely and plan forever, and it might never get there. Or we might really want it to not get there, like right now with this current Supreme Court. I don't think we want to impact the whole country at once because it will likely be negative on any front. And so I think that I have a survey, data from a survey of about 37 to 40 trans people in Massachusetts that Black Community Massachusetts did in collaboration with Rights Behind Bars. Any of those 37 are viable clients. All of them have things they need to happen and have tried to ask lawyers for help and, work with Black Community Massachusetts to try to get things done. Any of them could be the impact case that will change all of Massachusetts. Any of them could bring a case that has a ton of resources that doesn't actually change anything for anyone else because it settles out after being litigated for years. Massachusetts, on that note, has had a very recent, huge win in a case that has been litigated for years. The client is being ordered to transfer to a women's facility pre-gender affirming surgery. Often you'll have facilities say that they'll only allow transfers to women's facilities if they have gender affirming surgery first, because they're scared of penises, and the penis is inherently dangerous, and so a person with a penis cannot live with women. But a court has now ordered a transfer pending the gender affirming surgery process. And so, that's huge precedent for lots of other district courts to see that that's possible. And I think all of the attention on this one person has allowed for that precedent to occur. And the energy put in that one case, right? Maybe it won't help everyone else because everyone else trying to do the same thing might actually need the same amount of resources. So I don't actually think my work right now is to try to help the most people with what I'm doing, but rather ensure that the work I'm doing is in alignment with my larger vision. And the abolition as my goal and thinking about helping folks who are suffering as the goal, it's really humbling to know that, I'm one of many people trying to do this. And I don't want to think anymore about trying to make the most sweeping change. I can just do quality work and help the people in front of me because many, many, many people need it.
If I could just jump in for a second. So I'm fascinated by what you've laid out there, and I actually agree with very much of it. As someone who has spent now 20-something years in an organization that does try to figure out, okay, how can we help the most people? I think you're onto something because, look, I think we've made some good guesses, and there are a whole lot of cases that did not work out, did not create new law, settled and took an off-ramp there, and it is awful hard to tell in advance which one is going to be which. We've got an example sitting right here of D. Farmer's case. You got to the Supreme Court because you got yourself to the Supreme Court. And then folks, some of my colleagues at the ACLU helped out because there it is. It's there, and let's do whatever we can to help. And that's not, it's an important part of the process, but you're the person who made it happen. And so you can't script that stuff. And so I think we need all kinds of approaches to make the change that we all need.
For me, I think the most impactful case is the one that centers the voices and the needs of the people who are impacted the most. I think that there is a perspective of attorneys and attorneys' egos and litigators' egos that has a tendency to think of litigation as maybe not being so human-centered or client-centered. And so to me, that really focusing on centering the client is what makes an impactful case regardless of the outcome of the court. And I think for me in working with clients, such an important piece is talking about just because the court did not see you or hear you or validate you does not mean that you are not valid and that this did not happen to you and that this was something. So to me, impact is about how you relate to your clients and the folks you're working with because you can't know what's going to happen in the court. For me, with my career, I have taken a more movement lawyering perspective. And so working with students like you, if folks want to help create legal resources or do advocacy for trans people in custody, I focused my work on creating programs to get more people involved where because of the PLRA and sort of the cap on attorneys' fees and the way that sort of keeps the private sector out of the space, how can we get pro bono support from law firms? How can we get pro bono support from students? And so for me, that's sort of how I've focused on it is how can we get more people involved than traditional litigation.
Okay, before we take another question, I need to give you the second and last CLE code. So for those here for CLE credit, or getting CLE credit, you're here for many things beyond the credit. We all know. But the code here is learning well. So learning well, all lowercase, and there's a space between learning and well. I did not come up with the codes, and I don't know who did. But learning well. You got it? Okay. Let's take other questions.
I know Dee Farmer talked a little bit during the keynote about maybe using state tort law and I guess med mal essentially, negligence. And I'm just curious, given how demanding the Eighth Amendment standard is and how hostile federal courts are, how much you're using state law and state courts.
So whenever I am litigating especially Eighth Amendment claim what usually happens is inmates contact me about their claim, and I go into investigation, look at the issue, talk to them, and then I put together the complaint and file it, and then go about finding them a lawyer to represent them. And I usually will always try to include a pendant jurisdiction claim because they are usually much easier to prove than the constitutional claim. And so, but, you know, if you have a very big constitutional claim that you know is going to be hard, I also look for smaller claims to keep it in federal court so that the federal judge can decide the pendant claim. For example, if there's illegal segregation, you know, I will be sure to include that claim in addition to the denial of gender affirming care. So even if the court denies the gender affirming care, I know that they will continue with the segregation claim, which will allow them to also reach the pendant jurisdiction claim about the gender affirming care.
So I have so many thoughts about this. Thank you for asking this question. First, we can learn from, I think, the same-sex marriage movement, which went state by state and was in state courts very often. Not always, but very often. Because it's marriage is state law, right? And so I think I think that right now there's energy behind doing state con law. And in the prison litigation context in particular, it's MacArthur Justice Center has a state constitutional law project. A lot of repro rights orgs have state focuses, especially after Dobbs. Rights Behind Bars is interested in working with them, but we've not yet decided if we're going to jump in on this state project that MacArthur is leading. It's the wild, wild west. Like, you're going to get some statutes are better, some statutes are not as good. Like, there are different standards at play that are sometimes broader. And so you have to just work within the state system. And that's the thing. Sometimes the state system might be slow. Sometimes they might not be favorable judges. But if you think you have the right legal argument, you can go forth. What I worry about with this kind of 50-state approach is, like, it's really tempting because it seems like, you know, so much to mine there. But I don't know how much more resource intensive it will be to go state by state when taking that approach on. I am a fan of it when we know that it's a, you know, better state law and generally looking like a liberal state. I don't know how helpful this will be in a post-Dobbs world in red states. And so does that mean we're just further dividing who has rights and who doesn't? But we have to do something, right? And so I do think that, this is going to be a lot of my career moving forward. There's a book called 51 Imperfect Solutions by Judge Sutton that's all about this as well, and kind of having every state having two bites at the apple. You have federal law and the state law to try the constitutional claim, and it, I think, is going to be what we have to start doing given the federal courts.
I will again plug, if any students are interested in doing the research for state court claims, come find me. I'm doing 50 state resources. Connor helped out, so you can ask him about it.
And as we're coming up on time, I don't know if anyone else wants to plug their organization, internships, volunteer opportunities. I mean, a 50-state survey sounds pretty great, so y'all should be checking in with Whit after this. But any final parting plugs or directions for our students and guests to go to? Your orgs are all in the program, and everyone here knows how to use Google, I believe, so you can look them all up and find their organizations that way as well.
Coming up on the end of our time, quick plug on our behalf. Please, 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 people on Zoom, come tomorrow in person. We'd super appreciate it. 2 to 4, Lipton Hall, we've got a great intersectionality panel on queer activism. It's going to be super important. Great to get some FaceTime with our panelists. Afterward, a workshop where we're going to be working with Project Let's, super good coalition building organization here in the city, does a lot of really vital work, good chance to network with other like-minded people who might be working in the space. And then we've got happy hour. So if you don't want to come to anything, come drink with us at Playhouse from 6 to 8. We'd be very happy to have you. Thank you so much.
I just want to end with a huge thank you to our panelists here. I know you've really inspired me with your tireless advocacy. I know we were talking about a lot of really heavy and difficult things. So thank you all for being out there, fighting for all of our rights in some of the hardest places. So thank you.